folks, and welcome back to Conveyancing. We are in the video series for formation of contract. We are in the second module for formation of contract, and this is video number 4 overall. Videos 1 and 2 we had a look at formation of contract. Video 3 we had a look at cooling off, and now video 4 we'll have a look at the more thorny issue of instalment contracts. So there are 3 main topics we need to get across for a decent understanding of instalment sales of land. The first one is how instalment contracts are formed, what are their characteristics, secondly the buyer's rights, what it gives to the buyer extra special over and above the garden variety contract, and seller's restrictions over and above the ordinary form of contract that would be used. So looking at the nature of instalment contracts, what are they? Well, they are defined in Section 71 of the Property Law Act as executory contracts for the sale of land, whereby the purchaser is bound to make a payment other than a deposit without becoming entitled to receive a conveyance in exchange. That's the ticket down the bottom there. That's what really sets these kinds of contract apart. So looking at those different terms that I've highlighted in bold there, in turn, executory contracts are just simply contracts that have yet to be performed. Sale of land, well, no real rocket science here. It includes an agreement for sale or an option for sale, like we were talking about previously. One thing the text does say to be careful of when you're drafting up an option agreement is not to package in, or be very careful about how you're packaging in option fees and the payment for option fees, because if you sweep those into the deposit and they are interpreted as forming part of the deposit, you may find unwittingly that your deposit actually goes over the amount of the prescribed percentage for deposits, and that can tip you over into an instalment contract when perhaps it was not intended. So we'll talk about prescribed percentages in just a moment, but that's just a quick note on option agreements there for you. So an executory contract for the sale of land, that can include option agreements as well. Under these agreements, the purchaser will be bound to make a payment, and as I said, that payment will not be in exchange for a conveyance or transfer. So even though you've made this payment, it doesn't mean that then the next step is for the seller to transfer over the land to you as buyer. So it's this fact that you're paying money without immediately expecting to get a conveyance in your favour that makes this type of contract an instalment contract, and therefore qualifies it for some of the extra protections around buyer's rights, some of the extra restrictions on the seller's ability to deal with the land that attach to instalment contracts. So what are the nature of the payments that might qualify as payments under an instalment contract? Well, they have to be payments from the buyer to the seller. So if you're looking at contractual obligations to pay to a third party, then they're not the kind of payments that will be in danger of causing a contract to be interpreted as an instalment contract. Obviously, they have to be made before settlement, because the nature of this thing is that you pay over your money without getting the conveyance. So payments that are made at settlement won't get caught as instalment contract payments because they're being made in exchange for a conveyance. Again, the text says be very careful, because pre-settlement payments, for example, for interest on deposit in return for an extension of settlement date, may in fact tip your client over into, unwittingly, again, an instalment contract arrangement. So there's just various different points at which negotiations may cause some danger that you should be cognizant of for your client in terms of converting what they thought was a plain old contract into an instalment agreement. The payment has to be other than a deposit. Okay, so deposit under Section 71 of the PLA means a sum not exceeding prescribed percentage paid or payable in one or more amounts and liable to be forfeited. Okay, what is the prescribed percentage? Under the Land Sales Act and the BCCMA, the maximum is 20%. For everything else, the maximum is 10%. So your ordinary residential sale will attract a maximum of a 20% deposit there. You can actually pay that 20% in 2 or more payments, as it says in Section 71, so it won't lose its character as a deposit just because you paid it in a few different parts. Okay, super important. You can still retain your character as a deposit and therefore keep your contract out of the category of instalment contracts, even though you've paid in part. So the kinds of things to be careful of, as I say down there, the last 2 bullet points, payments that are made over and above the deposit and are not in exchange for a conveyance, you're going to be in very real danger of constituting an instalment contract there. So payment of interest on the deposit to the seller before settlement might exceed the prescribed percentage for a deposit and therefore unwittingly constitute an instalment contract. Starco Developments is the case authority there. Similarly, if the buyer has already paid a full deposit up to the prescribed percentage and then the seller offers an inducement saying, look, the moment you pay your full deposit, I will immediately give you a rebate on the purchase price, then unfortunately that full deposit that was up to the maximum prescribed percentage is going to go over the prescribed percentage because of the rebate, and therefore you're going to be in instalment contract territory yet again. So there's a few things just to be mindful of there, as I said, when you're structuring agreements after these, negotiations that have gone on between the parties. It all comes down to how it's packaged and whether it might fall foul of this kind of arrangement, instalment contract arrangement. The character of a deposit is that it's liable to forfeiture. Okay, so you want to make sure that your deposit is liable to forfeiture. Sometimes a contract will stipulate that a deposit is non-refundable. Where the seller really wants to keep the buyer on the hook, they might stipulate that the deposit is non-refundable. This has danger written all over it because that then means that it's not liable to forfeiture. It has basically already been forfeited. So sometimes courts will be kind and interpret this kind of provision rather kindly as basically the parties intending to say that it's non-refundable unless the seller defaults, and if the seller defaults, well, then it's going to be refundable, in which case you haven't tinkered around with the nature of the deposit and you haven't placed the parties in danger of creating an instalment contract. However, sometimes courts have interpreted these non-refundable deposit provisions quite literally, and if that's the case, if a deposit is said to be non-refundable, then it's not really a deposit and it falls more as a payment it's otherwise than in exchange for a conveyance, and therefore an instalment contract can be formed. So that is the issue of the nature of deposit payments so far as they are concerned with instalment contracts. What do instalment contracts result in? What are the consequences of an arrangement being interpreted as an instalment sale of land? Well, it means that the buyer is going to obviously having to be making payments other than exchange for a conveyance, and therefore needs to protect themselves more than perhaps the average garden variety contract arrangement. So caveating is a super important decision to be made here. Under Section 74, interestingly, because of the often longer duration of an instalment sale of land rather than an ordinary sale of land, it may mean that the buyer needs longer protection, and therefore your caveat is not going to lapse like an ordinary caveat for the sale of land, because you do need that length of protection. Another, I guess, tool in the buyer's armory, so far as an instalment contract is concerned, is that they can require, in fact, direct the seller to deposit the title deed and a transfer, a duly executed transfer, to a prescribed authority, and that will be such trusty people as solicitors, banks, trustees, and that kind of thing. That will then be held in escrow pending discharge of the contract. If the seller defaults and refuses to comply by depositing the title deed and the transfer, then the seller will be deemed to have breached a condition of the contract, and with all of the consequent rights that flow from that arrangement. So that's the first thing. The buyer can require the deposit of the title deed and the transfer document. The other thing is that the buyer under Section 75 of the PLA can require a conveyance. They can actually direct the seller to convey the property to me, and you're thinking, hang on, they haven't paid all of the purchase price. Well, that's right, but they have to execute a mortgage in favour of the seller in return. Okay, so as long as the buyer has paid 1/3 of the purchase price, they can serve a notice requiring, basically directing the seller to convey the property to them conditionally upon execution of a valid mortgage in favour of the seller. So what you may have thought was an ordinary contract with an ordinary buyer, all of a sudden you have a buyer as mortgagor and you've become a mortgagee. The seller also has a correlative right that corresponds to the buyer's right to require a conveyance. However, you'll see the text notes that there's all sorts of problems with this provision, not the least of which is that the seller has to actually advance a sum of money to the buyer for payment of all of the ancillary costs involved with the documentation that goes along with a conveyance. So if the transfer duty, the legal costs and this sort of thing, yes, the seller can add that sum to the mortgage that's created in this arrangement, in this process. However, the very big but here, and it is a big but, is that before you can add that sum to the principal amount of the mortgage, the buyer has to agree. So what if they don't agree? Can lead to a bit of an impasse. The other thing that's a problem here is that the buyer in the meantime has cash flow issues, because they're going to be the one that has to foot the bill for the preparation registration costs, in the meantime, and then be paid back over time via the mortgage. Yes, the Property Law Act implies a power of sale in every mortgage made by instrument. So, registration is not so much of an issue here. You're still going to get your protection. You can still go ahead and possess the property and sell it off as mortgagee in possession, even if the mortgage document doesn't get registered. But for the seller, at least, as you can imagine, and as the text points out, exercise of this right has some issues with it. Okay, so what are the restrictions on the seller's rights? There's three big ones: prohibition on mortgage, prohibition on sale, and restraints around the way that you can go about terminating these bad boy contracts that are instalment contracts. Firstly, the prohibition on mortgage. Obviously, the seller can't do it because it's prohibited. If they do, then the buyer has themselves an option to avoid the contract at any time before settlement. You've got to serve a notice of rescission. That's fine. When can you do this? When is this right triggered? Well, if the seller has engaged in procuring a legal mortgage, an equitable mortgage, if it has made a variation to its existing mortgage to allow further funds to be drawn down, that will be the kind of prohibited mortgage that falls within Section 73. Where a seller does have a portfolio arrangement that allows them to draw down progressively as they need the cash, they can still make further draws on that portfolio, but they can't go over the maximum of that portfolio as at the contract date with the buyer, because otherwise it will be constitute or construed as one of these prohibited mortgages. If the new mortgage to the subsequent buyer does end up getting registered, then the subsequent buyer is going to have indivisible title. So unless there's one of the exceptions to indivisibility, like fraud or personal equity, they're going to prevail over the original buyer. If the new mortgage is not registered, then you're going to have the usual situation of competing equities, and so that's where your judicial notice will be taken of things like the conduct of the parties, whether they had notice of the other party's rights. So did the subsequent buyer know that there was already an instalment contract buyer sitting out there in the wings? If so, that's going to taint their hands or sully their hands somewhat in this situation. What representations were made? Was there any negligence? And as I say on the second to bottom bullet point there, failure to lodge a caveat by the original buyer under the instalment contract may in fact be sufficient to justify the priority going to the end buyer, because basically what you're doing by not lodging a caveat is you're equipping the seller with the instrument of fraud, basically. So you're enabling them to go and sell to another party. However, in this kind of situation, the buyer could still rescind under Section 73 upon finding out about the subsequent mortgage and recover their money anyway. So that's the first restriction on the seller's rights. The next one is prohibition on sale. So once you've sold to a buyer under an instalment contract, you can't go ahead and sell to someone else. Again, the contract is going to be voidable at the original buyer's option. Interestingly, no statutory provision allowing rescission here, but obviously what will the situation at law be? Well, you had one contract, buyer and seller, and then the seller has purported to then on-sell that same property to a different buyer. Obviously that's going to be a repudiation with all of the consequent rights that flow on from that. So the original buyer would have the right to accept that repudiation and then terminate and sue for damages. Now, if the subsequent buyer has taken free of the instalment contract purchaser's rights, for example, they've gotten registered on title, the instalment contract purchaser can sue for total failure of consideration. Sue the seller, or they can sue the seller for any profits that they've made on the sale to the subsequent buyer. What about if the original purchaser doesn't want to let go and actually wants to enforce the transaction? Can they enforce it against the subsequent buyer? Again, this is going to end up as to who has the stronger rights and whether or not the subsequent buyer has gotten registered on title. Again, that's only going to be defeasible if you've, fall within one of the exceptions to indefeasibility, like fraud or personal equity. If the subsequent buyer has not become registered on title, then again you're going to be reduced to that usual competition between equities, and the judge is going to have a good hard look at what everybody's done, what the respective parties have done to protect their rights, what representations were made, whether there was any negligence and so forth. So that is the second big restriction on a seller's rights. And the last main restriction on a seller's rights is the way that they can go about terminating the contract. You can't just willy-nilly terminate a contract for instalment sale of land. because of the fragile nature of the buyer in the whole transaction. They've started to pay over money, sometimes a lot of money, on the faith that they're going to have a conveyance made to them at some point, and you can't just rip that away from them and expect to walk away. What you have to do is you have to follow the termination procedure, and that is you have to serve the buyer that has come under default in the transaction. You have to serve them with a notice of default, and you have to allow them the full statutory 30 days to correct their default, and after that you can then go ahead and terminate. So you have to give them plenty of notice, and you have to follow this statutory process to the letter, because the big risk here is that if you do not and you try and terminate early, then your termination will be taken as a repudiation, and the buyer can then accept that repudiation. They can terminate and they can sue you for their losses. However, as I say in the last bullet point there, you're not required to give a notice when the buyer does some naughty things that do justify termination and fairly quick action by the seller. Things like where the purchaser has themselves repudiated the contract, or big one here is where they've failed to pay even the deposit. At that early stage, a failure is of such gravity because it indicates the tenor of the relationship between the parties for the rest of the transaction. Then you don't have to serve this notice either. But that's a big one. The seller can't just go ahead and terminate however they want to. They have to follow the statutory process. And that is, as I said, the very thorny issue of instalment sales of land. And once again, we've passed the magical 15-minute mark, so I think I'll leave it there for this video, and we will come back for video 5, and we'll finish up on the last 2 topics in formation of contracts. See you then, guys.